Good morning. Welcome to our webinar, Friday morning and the start of the weekend. And hopefully we can learn from each other today. Today's topic, general questions on divorce in South African law. We have some people that subscribe to the channel from overseas. So please remember, we're applying South African law here, and of course some of it might overlap with international law, but it's important to note that each country has its own laws regarding family law. For one example, in America, they might not have the principle of income into property, out of commuter property, with accrual, without accrual. As South African law, they might have a different system. Some of them follow the equitable distribution system at divorce, and some follows the commuter property, and so on. So it's important to note that the laws around the world are not the same regarding family law and any other law, criminal law, corporate law, and so on. But today's topic, general questions on divorces, South African law. Please remember our webinar tomorrow at 11:30 is the official time. Please, if you have not registered, register as soon as possible. We're only allowed to have we can only have 100 people join the Zoom. And if you cannot attend the Zoom tomorrow, please note, pose your question, it will be answered. You'll get a video link later on and you can watch the video dealing with your specific legal question. It is anonymous, nobody will know who it is. So, lawyers are hard to get hold of, and you pay a lot of money to consult with lawyers. And in this specific way, if you have a legal problem, pose it, have a lawyer answer it for you, and that's how we all learn and benefit from that. Okay, that was the advert for tomorrow. You'll see it later on again. The first question, after how many months can I get divorced from my spouse after getting married? An interesting question. Many people, not many people, but some people, they get married and they found out, oh dear, this was a very bad idea. Both parties come to that conclusion and they would like to get divorced. But now the question is, how long should they wait? Is there a time period, a lapse of a certain amount of time? Must they first go for counseling? What are the requirements? And the long and the short of the matter is there are no specific time periods applicable. If your marriage has broken down irretrievably, meaning it's over, it cannot be saved, done. And then soon thereafter, you can approach the court and the court can make a decision as to whether or not that has happened. And if that is the case, the court will grant a decree of divorce. That's just how it is. The law does not focus on specifically stipulating that a marriage has to be a certain amount of time, a certain period of time, X and Y has to take place. If the judge is convinced a marriage has broken down, then what else is there to do? Of course, a complication could arise if one party says, no, the marriage has not broken down, we are happily married, my spouse is being unreasonable here, there are prospects of reconciliation and so on, there's kids involved. Judge, give us some time, let us first go for counseling, that's something else. You can argue that later on. However, if both parties want to get divorced, the court more than likely will grant a divorce, and of course if the court is convinced that the marriage has broken down, even if you were married for a week, a month, I do not want to say a day, I'm certain if you're married for a day, you should of course try something afterwards. But if the period is very short, the court will divorce you. Question number 2. Is it possible to file for divorce if my spouse lives overseas? Interesting question, very valid question. Many people ask that question. It's a conundrum because you're living here in Johannesburg, Cape Town, KwaZulu-Natal, wherever you are living in, and your spouse moved overseas, which was most probably agreed upon for earning capacity, business being scarce in Cape Town, whatever the case may be. Now things happen, the ties change, a lot of things can happen when the spouses aren't together, but now they come to a conclusion or a decision, or one party, the one living in South Africa, decides, you know what, I am tired of this, I would like to end this marriage. That's what the spouse wants. But the spouse lives in the United States, in the United Kingdom, wherever it is. How do you do that? Which court do you go to? Must you go to the court in the States? Will it be expensive? What are the requirements involved? Now, in South African law, divorces are quite simplistic. As long as one of the spouses lives within the jurisdiction of the court can entertain a divorce. Let's apply some logic here. If the parties got married in Johannesburg, only got married in Johannesburg, and they live in Cape Town, the question is, can you get divorced in Johannesburg? No, you can't get divorced in Johannesburg because Johannesburg only done the marriage, but the parties aren't living there. They're not domiciled there. So make the example most probably better. They just got married. They went on holiday they went on holiday in Johannesburg. They got married there. No plans on living there. Just for a weekend away. They came down back to Cape Town. Clearly, Johannesburg is only the city where they got married. The same way if you got married in America, United States, but they live in Cape Town. Cape Town is their home. Applying our scenario, one of the spouses went to the United States to go for work and so on. Now, which court has jurisdiction? It will only be the Cape Town court that has jurisdiction, or the court in the States where the other party lives, but obviously I do not know United States law on jurisdiction regarding marriages or divorces. So in our scenario, seeing that one spouse lives in Cape Town and the other spouse lives in America, how does that work? You'll first have to obtain the consent of the court. They call it edictal citation application, whereby the court will grant you permission to serve the divorce summons on the other party via email, via sheriff in the United States, via different process in the United States. Maybe an attorney that side can serve it upon the other party. Because in South African law, in order for you to institute divorce proceedings, the sheriff of the court needs to go to the other party, to the defendant in our example, and he has to serve the summons on the other party, stipulating your spouse would like to divorce you. Here is the summons. If you are opposing the summons, if you have a problem with this, please go to court. Here are the court details, and file a notice of intention to defend and follow the court proceedings, because both parties are living in South Africa. And that's how the legal process works. In our example, one party lives in America. We do not have sheriffs there. We do not have authority there. We do not have any jurisdiction in America. Also, our local courts in South Africa does not have that. So what happens then? You have to get the court's permission in South Africa. May I serve this documentation upon the other party because the other party lives overseas? So it can be done via email, maybe Facebook possibly, theoretically possible, via sheriff that side, via attorney that side. As long as the court can be convinced that this is the best and the only means to serve the documentation upon the other party. Now let's say that took place. The other party was served with this documentation via email or a sheriff that side, whatever they have that side, and you receive a document stipulating that took place, either an email from an attorney stipulating I served this documentation on the other party after receiving the court's consent, or a document from the sheriff that side or an attorney that side, whatever was authorized. Once that has taken place, the normal proceedings regarding a divorce will follow as if that person was served in South Africa, meaning the person will now have 10 days to file a notice of intention to defend, another month to file a plea with a counterclaim, notice to strike out, whatever applies to the circumstances. So in answering question 2, yes, it is possible. However, you have to first get over the hurdle of getting the court's permission to serve this party overseas via an edictal citation, or basically a different form of service, either via email or for a process that side, via an attorney that side, via post, whatever the case may be, as long as the court can be convinced that the other party will receive the documentation or notice of the specific divorce process pending in the specific court, and the matter proceeds as normal. If the person in the States received the summons via email, in my example, he or she will, of course, file, if they want to file a notice of intention to defend in the local courts in Cape Town, in our example. And most probably appoint a correspondent or an attorney here locally in Cape Town to deal with the matter on his or her behalf. And that's how the matter will proceed. The same way, for example, if both parties lived in Cape Town, they started divorce proceedings, the other party filed a notice of intention to defend, and he or she moved to the United States, but the divorce is still pending. Still, the matter still proceeds as normal, as usual. And in my example early on with the edictal citation, same way, once it has been served, the matter will proceed despite where the parties are living. And the same way, if you are the plaintiff and you institute a divorce proceedings in Cape Town, and tomorrow you decide to leave the Western Cape, the court still has jurisdiction to finalize the divorce. Let us move on to question number 3. Is it advisable to get married with accrual? Interesting question, and a question which gets posed to me quite often. As a family law specialist, of course, I will deal with this scenario mostly at divorce stages, when the parties got married out of common property with the inclusion of the accrual regime, and there are obviously problems involved, or they require advice on it and how does it work. The sad thing is that many people do not understand how the accrual regime works. I consulted with somebody yesterday as well, and they did not understand how it works. They have a certain perception. It could be because when they got married, of course, they were in love and they were told, this is a good way. What's yours is yours. What's his is hers. Oh, sorry, what's his is his. What's hers is hers. And that's how it is. And at death or divorce, you guys will share in the accrual. And they understand a bit what it means, but they do not necessarily comprehend fully. And they get married. And as time goes on, the marriage goes off very well, and now problems arises. Now they need to now know what on earth did I get myself into. Was this a good idea or was it not a good idea? Now, the accrual regime basically means that the parties are firstly married out of common property, meaning what belongs to one spouse belongs to that spouse, and that's it. That spouse, both spouses can do whatever they want to do with their money, with their property. They can dispose it, whatever they want to do with it. The only time the accrual kicks in is at death or divorce. Therefore, if in my scenario I give all my clients, if the wife stayed at home, she ironed the shirts, she looked after the kids, took them to school, taught him how to read, tutored him, was a homemaker, and the husband was the one that went to work. He excelled. He had nice clothing on, clean clothing. The house was always clean. He came home to home food, and he excelled. He went to business meetings, developed himself, extremely wealthy because of his wife supporting him. Unfortunately, because she's married out of common property with a accrual regime, her estate is not worth much, but her husband's estate is, and that is what it is. To make her feel better, obviously, should he leave her, or should they have problems in the marriage, or should she die, what may happen then? His estate, his wealth will have to be divided, and half has to be given to her if she's worth 0 at the time of divorce or death. She will share half in his accrual of his specific estate. So she will be at least appeased to the fact that despite him working and her staying at home, should he catch on nonsense or should something happen in this marriage, she will be entitled to half the growth of his specific estate. And he'll be entitled to half the growth of her estate. So what basically happens is we work out the commencement value that's basically written in the antenuptial contract. It's either 0 or 10,000 or 50,000 rand. Certain properties excluded from it, whatever the case may be. Then we work out the growth from that specific amount up. So if the commencement value was 50,000 rand and at the divorce it's 1,050,000 rand, automatically his growth was 1 million rand. And let's say, for example, her one was 50,000 at the start, but at divorce it's 0, automatically we work it out based upon that, and then we add the 2 and we divide the 2, and basically that's how the accrual gets worked out. She can be at least comforted by the fact that should something happen in this marriage, despite her being at home and the husband working and earning millions of rands, she will be entitled to half of that. And at the same time, when she dies, her heirs will be entitled to half of that. I hope that assisted you, or we in some way learned from that. If you I see we have a question on the Facebook Live. Let me deal with that in a moment's time. If you have any questions regarding any of these specific 3 points, you're welcome to pose it to me. But at the same time, please do not forget to register this below here. You can see the link, talalaw.co.za/register. Let me deal with this question. I'll pose it onto the whiteboard. Let's just deal with that. Okay, so it'll be question 4. It was, my apologies for that. I never copied the whole part. It goes like this. Here's it. So that's a question live on Facebook Live. It goes as follows. Good morning, Advocate Mohammed. I'm not sure if this would be a relevant question. Can a high court case, any court case, expire if the applicant hasn't perused it in 3 years, pursued it in 3 years, I presume so? No, it wouldn't expire. It wouldn't expire. So I would presume the documentation has been filed. The other party, it was served on the other party, and basically nobody done anything after that. Basically the matter would still be there. However, the challenge you have is that the data, the information which has been in that application might not be relevant anymore. Let us say we're dealing with a child custody matter. I'm using an example over here. And we're dealing with kids ages of, let's say, 7 years old. That's the age of a child. And the parents all living in Cape Town. And 3 years later, when you now want to pursue this application further, now go ahead with it. Things have changed. The child is now 10 years old. You're no longer living in Cape Town, now you're living in Johannesburg. So I would actually advise you to withdraw that application and file a fresh application. Because the data, remember, an application has in it the evidence, the data, the facts which you're relying upon. A summons, on the other hand, has basically the allegations being made, like a divorce summons. The parties, these are the parties, they got married on this date, the marriage has broken down, and this is what I want. No evidence, a lawyer signs it, 2 pages long, basically. However, an application, the evidence which the parties would have brought to the court would be stated in that, and you go to the police station, you sign it as an affidavit. Sometimes the documentation are 20 pages, 30 pages long. So going to that over here, I would say specifically stipulate that yes, an application wouldn't necessarily expire, but the information that's in it could have been outdated, could be stale, and I would actually advise you to withdraw that application and file a fresh application. If you hope that answers that. If I have not answered that, feel free to comment further. I see you on the Facebook Live, so that's fine. I know it will be you. I have another question. Let me put that down. Another live question, question 5. Okay, so something else of it. It goes as follows. Hi, Advocate. I'd like to consult with regarding maintenance. How much do you charge? So I will answer that question a bit later on here. I'm not much want to promote myself online, but you can set up a consultation with us or with any one of our legal practitioners using the link www.ourlawyer.co.za/advice. I'll type it over here, www.ourlawyer.co.za/advice, and we can take it from there. But I will answer the question from a point of view from how does legal fees work and legal charges work. It's very difficult in a family law matter to advise a client what will the ultimate cost be in their specific legal matter. For the sole reason, we do not know if the other party will oppose the matter, if the other party will, I can say now, how much they will fight, how much documentation they will file. So it's probably easy to work out the estimated cost of an application based upon the client's instructions. So if a client comes to me and asks me, Advocate, what would it cost to draft a divorce summons? Based upon the fact that there are only 2 minor children involved, I would like to have custody over the minor children, X, Y, and Z. Very easy. You can work it out. There's probably 3-4 hours of drafting time, maybe an hour consultation, drafting a parenting plan, drafting a consent paper if need be. So you can work it out and you can compartmentalize it. However, you do not know what the other party will file at court. Will he file a simple defense, a complicated defense, how much hour consultation is required, etc. The same with the child custody application. You consult with the client, you gauge in, okay, for you, ma'am, I presume you most probably spend about 10 hours drafting or consulting. I'm sucking now, giving a hypothetical example. Now you spend that 10 hours and you stick to your bill. No, you have to honor your bill, your quote. But the other side comes with 200 pages of allegations that needs to be dealt with. You didn't foresee that, and you cannot foresee that. Therefore, you can only quote the second part once you've seen that specific documentation, and then you can advise the client, you know what? Our initial documentation was 20 pages long. They came in now with 70 pages. We need to unpack all these things. We have to deal with all these things. I foresee now, my initial quote was 10,000, and for the initial application, for argument's sake, this must probably have to be 20,000 then. I mean, general. I'm sucking dealing with a hypothetical example. Or initially I spent 10 hours, now I might have to spend 30 hours to deal with the opposition. Because the opposition deals with A, B, C, and D, which we dealt with in our papers, but they also bring in E, F, G, H, I, J, K, L. They bring all these other aspects into the mix, which need to be dealt with. And if it is not dealt with, of course, the court will obviously make a presumption of why not dealing with these things. Because it may be relevant, it may not be relevant, but whatever the case may be. In court as well, how long are you to be in court? Is it 1 day? Is it 2 days? Is it half an hour? Is it 20 minutes? So all these factors will have to be determined based upon how things evolved. But initially, it's easy to give a quote, generally based upon experience, because I deal with these type of custody matters on a regular basis, and I can gauge, your matter falls under that parameters. However, when it comes to predicting the future, what the other party will do, that is extremely hard. So I hope I answered the question about the possibility of quoting, but I will contact you later on regarding that. And I thank you very much. We've got a comment further from question number 3. And this was a further comment. Brilliant answer. Thank you. Thank you very much. I don't think it was brilliant. I think it was just more based upon experience. But thank you for that comment. I have an additional question here on the live chat on Facebook Live. Let me copy it in first. And I hope you all also registering for tomorrow's webinar, whereby we'll spend about over an hour dealing with this interaction, and I'll be happy to do that. Question number 6. Let's unpack that one. Okay, let's go. What can I do as we in the process of the divorce, but my wife denies me weekends and days with my girls? She sent a letter via her attorney to visit the girls, only on weekends supervised, when there's no issues. She just being difficult because the breakdown of the marriage, please advise. Now, there's 2 aspects I'm seeing here. You are mentioning that there is a pending divorce. Now, my advice to you firstly would be, because there's a pending divorce, I would advise you to make an application for interim care and contact rights. For example, in the High Court, it will be a Rule 43 application. So I would advise you to make that application as soon as possible, and for the court now to hear the issues involved here, so the court can now decide what will be in the children's best interest going forward regarding care and contact. So that's my advice to you. You take the matter to court. The mother obviously has her own view, her own, I wouldn't say issues, but her own agenda, how she plans on getting ultimately what she wants. I do not know if she wants to get primary care custody. I'm just being general here. I'm not specifically saying it applies to your scenario. You need to have your own agenda as well. I advise that to all my clients. Remember, when you're dealing with a litigious matter, yes, you have an attorney, you have an advocate, you have a lawyer on board over there, but you have to have your own agenda as well. What do you ultimately want this matter? Do you want to play the game and hope for the best? It's like swimming down the ocean, into the ocean, hoping for the best. Hopefully, the best would be I get to the other side. But if that doesn't work and I drown and somebody saves me in the middle, is that the best? No, that's not the best. The best should be specifically what you want to get out of this deal. So you obviously want to have unsupervised contact to your minor children, and maybe ultimately you want to have primary key or 50-50 or reasonable contact every second weekend, half school holidays. If that is your plan, you need to start strategizing now. And one way of doing that would be to take this matter to the court ASAP, a application pending later, for example, because it's now a pending divorce matter. You approach the court telling the court, judge, magistrate, I am the father of these kids. We are pending divorce. I always had contact with the minor child that told in the past. There were never issues. Now, because we are divorced, we separated, and the mother has issues, I need to have contact with my children on a regular basis, unsupervised. These are the facts. Please assist me in this matter. And of course, the mother will say her thing, and then you will argue the matter, and the court will make a decision. So that is my advice to you regarding that. And I hope I answered those questions. I see no further questions on the live chat. If there are any, please, you have another moment to do that. Nonetheless, please remember to register for tomorrow's webinar. Those are the details you will be seeing shortly at the end of this video. And thank you very much for those of you who have posed questions on the Facebook Live. Thank you very much for that. Oh, I see the last comment for the gentleman. I should not have said gentleman, but of course, he mentions wife over here. But gentlemen, thank you very much for your comment. He says thank you, and thank you to all of you for partaking in this live webinar. I hope to see you tomorrow, Facebook Live, alternatively via the Zoom, and I'll appreciate it if you register for that. Okay, I see one final question before we go on. Let me deal with that quickly. That goes here. Furthermore, may the plaintiff claim funds back from the applicant when the applicant has not pursued High Court application. So I'm thinking between the lines over here. Claim funds back. So there could have been a Rule 43 application, and the court made an order specifically stipulating that that one party should give the other party a contribution towards the legal cost. That specific party did not use that money for the legal cost, and other person benefited from that. I think you have a strong case for that. So when a divorce gets finalized, ultimately, and then you can bring up to the court's attention that the person had funds paid to them and the person did not use that. But it's one of the difficult questions to answer, because how will the divorce ultimately get finalized? Do you want to claim that money back now before the divorce gets finalized? And that person might use that money to oppose that. So my answer would basically be, it's one of those academic questions. I don't think it will apply really in practice. But of course, you can bring it to the court's attention, and the court will determine what is best under the circumstances, what will be fair under the circumstances. Okay, I think we dealt with everyone's questions. If you have any others, you have a short moment. If not, I will see you live tomorrow. Please register for the live webinar. Have a lovely day, and I'll see you online soon.